There are three questions that this committee asks of every nominee. I'm going to ask each of you to respond briefly with just a yes or a no. We're going to start with Judge Arthur and move down the dais there. First, is there anything you are aware of in your background that might present a conflict of interest with the duties of the office to which you have been nominated?
No, Senator.
No, Senator.
No, Senator.
Second, do you know of anything, personal or otherwise, that would in any way prevent you from fully and honorably discharging the responsibilities of the office to which you have been nominated?
No, Senator.
No, Senator.
No, Senator.
And lastly, do you agree without reservation to comply with any request or summons to appear and testify before any duly constituted committee of Congress if you are indeed confirmed?
Yes, Senator.
Yes, Senator.
Yes, Senator.
Great, thank you. This first question is addressed to all three of you. The D.C. courts handle a very high volume of cases, and vacancies on both the Superior Court and the Court of Appeals have contributed to this very extensive backlog of cases. So I'm going to ask the three of you this question. I'll start with Ms. Briggs and then Judge Arthur and Mr. Ross. If confirmed, how will you manage your caseload efficiently while also ensuring that each person who comes before you has a meaningful opportunity to be heard?
Thank you for the question, Senator. Serving as a prosecutor for the last 12 years, I have a lot of experience managing a high-volume caseload. Coupling that with my knowledge of the laws in the district and my practice in Superior Court will allow me to quickly get up to speed if I'm fortunate enough to be confirmed and assist with the backlog in whatever section that I am assigned to. If I am confirmed, it would always be my goal to make sure all the litigants before me have an opportunity to be heard and understand the proceedings that are taking place while also efficiently moving my docket along.
Judge Arthur?
Thank you for the question, Senator. I've been a judge for nearly 11 years, and in that capacity, I have presided over thousands of cases. My approach to each one of my cases is to be fully informed about the issues and the evidence in each case. When I prepare, I make sure that I'm fully prepared for any anticipated arguments in the case. And when we're in court, I give each party an opportunity to state their case and make their arguments. And ultimately, I make my decision in an efficient manner. Thank you.
Mr. Ross?
Thank you, Senator. I would draw upon my experience dealing with high-volume cases, both as an AUSA and as a clerk for the Eastern District of Virginia. If confirmed, I would ensure that the litigants that come before me are prepared. I would assure that the court is always prepared for the cases that come before it, and I will work efficiently to move the cases to the court's docket.
Thank you. Ms. Briggs, what challenges do you anticipate facing as you shift from your role as an advocate to the role of an impartial adjudicator, and how are you preparing to make this transition if confirmed?
Thank you, Senator. The roles are different. An advocate starts out with a position that they must advocate on behalf of their clients or their employer. A judge must be neutral. It must listen to the facts, hear the parties, and understand the law. Serving as a senior assistant United States attorney in the U.S. Attorney's Office for the District of Columbia, I have had some experience in bringing in cases and being able to research and understand the law as it applies to the case that I'm reviewing coming into the office and making decisions on what, if any, charges will be filed. So I think I've had experience doing some of the things that I will be required to do if I'm fortunate enough to be confirmed as an associate judge.
This question will be addressed to all three of you as well. This time we'll start with Mr. Ross and then work that way across to give everybody a chance to be first up and last. This question, again, to all three of you. In your view, what is the proper temperament of a judge? Throughout your career, you have certainly developed the necessary elements of an appropriate judicial temperament. Have you, or at least give us examples of how that has occurred over your career? Mr. Ross, we'll start with you and then go to Ms. Briggs and Judge Arthur.
Thank you, Senator. I believe it's important for judges to be patient in dealing with the litigants that come before them and to be objective in applying the law to the facts. I had the good fortune of clerking in the Eastern District of Virginia for the Honorable James R. Spencer. He exhibited those characteristics each and every day, and I believe those are the important characteristics for a judge.
I agree with Mr. Ross. I would add dedication. My mentor, retired Florida Supreme Court Justice Peggy Quince. I was one of her first summer law clerks after she had been appointed to the Florida Supreme Court, and watching her and speaking with her about the dedication that it takes to understanding the law so that when the parties are before you, you have the knowledge base and you can listen to the parties fairly and then apply that law to what you have gathered in the fact-finding and listening to the parties. Thank you.
I agree with my co-nominees. I've sat on the court for nearly 10 years, and I've presided over thousands of cases again. I've also sat in the courts, many of the court's high-volume calendars. I find that in terms of temperament, it's important that each judge gives his or her full time and attention to each case, and again, give each party an opportunity to be heard in court to state their claims before the court. The court cannot be, and it is my view, that the court cannot exercise or exhibit any emotion when making decisions. The cases are limited to just the facts before it and the applicable law.
Very good. One last question for the three of you, and this time we'll start with Judge Arthur and move across. I certainly appreciate the strong commitment that each of you has made to follow the facts and the laws you've expressed in the previous question when you decide cases before you. But in practice, I want to know, how will you ensure that any personal biases or sympathies that you have, which we all have those innate to us, and how will you ensure that they don't impact the decisions that you make on the bench? Judge Arthur.
Simply stated, Senator, my personal views do not impact any decisions that I make on the bench.
Ms. Briggs.
I agree with Judge Arthur. I would add that each case must be determined by the applicable law, the facts in front of the judge, and applying that law to the facts. My personal beliefs have no place in the courtroom.
Mr. Ross.
I agree with my co-nominees that your personal beliefs have no place in the courtroom. Judges must be cognizant of the fact that they have to set their personal beliefs aside and apply the law objectively to the facts that are before it. I've had the good fortune, when I've worked at the Committee on Ethics, of engaging in that exercise of looking at facts objectively and preparing them for adjudication.